What's up, guys? Crypto Muser here with your daily news and analysis in the crypto markets. So today we have some more news coming out of the Ripple versus SEC lawsuit. There were two memos that were released to the public that show Ripple back in 2012 that they sought legal advice from a law firm, Perkins Coie. And basically what they did was they went to this law firm and said, here's our business plan. Let us know if we're, selling securities illegally, and, let us know how we can, go about business the right way, basically, right? So what Perkins and Coie said is that, we don't think you're selling securities, but there is a risk, a small risk, that the SEC might come after you in the future. So here are the steps to take to minimize that risk, right? So if you think about it, Ripple did everything you'd want a business to do. They sought legal advice. They tried to do this the right way from day one. And it goes against everything that the SEC has been saying, in that, the SEC is saying that, Ripple was reckless from day one. They knew they were doing something illegal. They were selling XRP as a security, and they're all criminals, basically, right? So what these memos show is the exact opposite. It shows that, Ripple were very smart. They were careful. They sought legal advice from day one. This is back in 2012, by the way, where this is like before, crypto was even a thing. I think Bitcoin was the only crypto back in 2012. So it just shows you that the steps they took from day one to make sure they did everything the right way. They did everything the proper way from day one. Quick drink of water. So in this video, I want to go over, because I'm not a lawyer, right? So I have two lawyers in the XRP community, and then I have the general counsel at Ripple and what they thought about these memos, right? So let's get right into it. But before I do, I just want to ask you guys if you could please subscribe, hit the bell for notification. Would be very much appreciated. And guys, don't forget, leave some comments down below, right? Let's start a dialogue. I've been in this space for almost 5 years now. Use me as a resource. If you guys have any questions about XRP or Ripple or anything involving around crypto, let me know. I'm a nerd in all this. I'm in the news, doing research on coins every day. I'm addicted to this stuff. So use me as a resource. Let's start some dialogue, guys. Don't forget to comment down below. But remember, like and subscribe, but let's get right into the video, guys. So James Filan, he's an XRP community member, attorney. He's always giving updates in this case, and he's a great follower on Twitter. But let's get into what he thought about these memos. So he says, overall favorable to Ripple and the individual defendants. Both memos are from Perkins Coie. The first memo was prepared in February 2012 and sent to Jed McCaleb and Jesse Powell. So just to give you a heads up, Jed McCaleb and Jesse Powell were the original founders of then Newcoin, but then became XRP and Ripple, right? So February 12th, they sent to Jed McCaleb and Jesse Powell. It says that if Newcoin is sold, Newcoin, just think XRP. If Newcoin is sold in the way it is, it could be seen as a securities offering. But Ripple then revised its business plan and went back to Perkins Coie, which issued a second memo in October 2012. And the second memo was sent to Chris Larson and Jed McCaleb. So I guess Jesse Powell left the business there, and then I guess that's when Chris Larson joined. So then it was Chris Larson and Jed McCaleb. So then the October memo was more positive, and while it said that there was a small risk that the SEC could disagree with Perkins and Coie, that Ripple credits, or XRP, should not be considered securities. The memo also suggests steps Ripple could take to minimize the risk that the SEC would disagree with Perkins and Coie. The memos cover the full landscape of legal issues, not just issues of securities, and I think show how careful Ripple is trying to be. Also, this is 5 years before the SEC really even started talking about digital assets. It seems to me that Ripple was being very proactive, which is very important. There certainly is nothing in these memos that suggests that Ripple was being reckless or ignored any substantial risks. In fact, the memo suggests the opposite, that Ripple was being very careful. So it's exactly what I'm saying here. The SEC's whole case revolves around this whole idea that Ripple were being reckless, and they were, they knew they were doing something illegal this whole time, and they were doing it all the wrong way, and they're all criminals, like I said. But what these memos show is that it's exactly the opposite, right? Ripple was doing everything they had to do. They were getting legal advice. They were trying to do everything in the right way, and it's just crazy because, the SEC already had a terrible case in all this, and each thing that comes out each day just making the SEC look worse and worse and worse. And this is just, icing on the cake at this point, right? So then I have Stuart Alderati. He is the general counsel, or the head lawyer at Ripple. And he said this about these memos. The conclusion of these now public 2012 memos is clear. XRP do not constitute as securities. The fact that Ripple had the foresight to seek legal advice from a prominent firm in 2012 in the absence of a clear case law and 5 years before the SEC even started talking about digital assets should be applauded. So exactly what I was saying. The fact that they did this in 2012 before cryptocurrency and digital assets were even a thing, right? Like I said, Bitcoin I think was the only digital asset back then. It just shows you that they took the right steps to do everything the right way, right? So that, he said, they should be applauded for doing this. This is a U.S. company. They should be applauded for doing everything the right way. And the fact that the SEC is going after them in the same, and as they come after them, then they're killing and hurting investors in the process, just shows you that the SEC is dead wrong in all this, right? And Brad Garlinghouse, right, he's the CEO of Ripple. He put this out about these memos. The truth is out there for everyone to read. What we see is that the SEC waited 8 years to decide that they disagreed with this analysis, decimating thousands and thousands of XRP holders, who they purport to protect in the process. So much for being mission-driven. So exactly what I was just saying. The fact that they waited 8 years to disagree with this analysis, they let XRP, sell in the open market for 8+ years, and then they come down with this lawsuit against Ripple with these false claims, and then they hurt thousands and thousands of investors in the process. And I love how he says, so much for being mission-driven, right? I keep saying this on this channel. It's amazing to see the SEC, the supposed people that are here to protect us, protect investors, are the one that are decimating investors, right? It makes no sense. I mean, they look worse and worse every day. And now, if you saw my video yesterday, you saw that Elon Musk is going after him now because in the settlement with Elon Musk a couple of years ago, it was for $40 million. And that $40 million was supposed to go to investors, right? Well, guess what? The SEC kept that money. So if just when you thought the SEC couldn't look any worse, they keep just repeating and doing these kind of things. And it just solidifies our case that the XRP community have and that other people have with the SEC is that they are this corrupt government agency and they need to be stopped, right? We need government oversight in this, right? We need Congress to step in and start an investigation and get to the bottom of what's going on in this agency because obviously nothing good, right? So let's get into what John Deaton, the head lawyer at for the XRP community says. Let me just get a drink of water. Just talking so much, my mouth is getting dry. Okay, so let me just get to hold on guys, let me get to the spot so I can, come on. Okay, I'm reading off my phone so I can read this the right way. Okay, so undisputed facts, timelines, and additions. 2012, Perkins Coie, the same law firm that helped write Hinman's Ether-free pass speech, informed Chris Larson Ripple credits, or XRP, aka XRP, is not a security. So the 2012 memo warned Larson there was a risk under the Bank Secrecy Act, or BSA. So the 2012 memos, let me just scroll down so you guys can maybe read as I'm reading. The 2012 legal memo stated that the law firm's analysis has never been tested by the FinCEN in practice, and therefore reliance thereon is not without risk. The Perkins and Coie memo was spot on because in 2015, FinCEN sued Ripple, claiming it had violated BSA. FinCEN's suit against Ripple was the first civil enforcement action against a cryptocurrency industry player, a case of true first impression in the industry. Ripple settled for $700,000 and agreed to comply with the non-securities regulations. Ripple was classified as a money service business, and pursuant to the binding federal agreement, Ripple stipulated any sale or transmission of XRP by Ripple Labs or any of the subsidiaries shall be conducted only through the entity registered with FinCEN. So in 2015, pursuant to this binding agreement with the U.S. federal government, XRP was declared to be a convertible virtual currency. So you see there, 2015, FinCEN and the federal government said that XRP was a convertible virtual currency. So then in June, let me just make sure you guys are all up to the right spot here. So then on June 13th, 2018, SEC enforcement lawyers wrote a legal memorandum analyzing whether XRP was a security under the Howey test. After conducting this in-depth legal analysis of XRP, the SEC enforcement staff did not recommend filing an enforcement action against Ripple. The next day, on June 14, 2018, Bill Hinman delivered his Ethereum free pass speech that Lowell Ness and Perkins Coie helped write. 2 months after, on June 13, 2018, XRP memo and Ethereum free pass speech, on August 20, 2018, Brad Garlinghouse and Joel Katz, or David Schwartz, the CTO of Ripple, met with Hinman and Clayton. At this meeting, Brad Garlinghouse loudly spoke out, "Ripple is living in purgatory over the lack of clarity with XRP." After Garlinghouse spoke out about the lack of clarity regarding XRP, neither Clayton nor Hinman provided any clarity by claiming the SEC considered XRP a security. 2 months after the XRP memo and the Ethereum free pass and a face-to-face with Clayton and Hinman, they said nothing. So after the FinCEN fine and settlement and the 5.5 years, XRP openly and publicly traded on over 200 exchanges worldwide, including in the United States. Also, the SEC allowed its employees to trade and own crypto assets, including XRP, without any restrictions similar to the ones in place related to owning securities. In fact, up until 2019, even SEC enforcement lawyers could own XRP without seeking permission or advice. Also, in 2019, the United States' largest exchange, Coinbase, went to the SEC in January 2019, informing the SEC that Coinbase had run XRP through its stringent regulatory framework and determined XRP not a security and intended to list XRP on its platform unless instructed otherwise. The SEC did not disagree, and on February 28, 2019, Coinbase listed XRP on their platform. And this is where it gets really deep, guys. Ready? 18 months later, on December 17, 2020, former SEC Chief Grunfest sent Clayton, Hester Pierce, Alan Roisman, and all the commissioners at the SEC a letter pleading not to sue Ripple over the use of XRP. Let me just get down to the right spot. Grunfest explained that everyone behind the decision is bring a lawsuit against Ripple and XRP are leaving the SEC. Hinman left the week earlier. Clayton was leaving in December 23rd, 2020. Mark Berger, Director of Enforcement, and someone who helped write the complaint was leaving. The Director of Trading and Markets was also leaving within weeks. Grunfest characterized these departures as a mass exodus never before seen of senior staff responsible for bringing a lawsuit as they walked out the door of the SEC, and that this exodus raised obvious concerns. Grunfest explained that there was absolutely no exigent or no real reason to rush this lawsuit, considering XRP had been traded for almost 8 years. Grunfest pointed out that after 2.5 year investigation, the SEC did not allege a single instance of fraud or misrepresentation. Grunfest stated in the SEC file that the SEC filed it. Grunfest stated if the SEC filed this suit would cause multi-billions in damages to innocent holders of XRP and no connection to Ripple, and that this harm to innocent holders would be the most significant in history of the SEC in a non-fraud case. Grunfest stated the SEC should not bring an action against XRP and leave Ethereum untouched because the SEC could not make a material distinction between Ethereum and XRP. Grunfest was the perfect person to acknowledge the similarities between XRP and Ethereum because he acted as an advisor to the Ethereum founders. He served as a liaison, basically, between Ethereum and the SEC before and after the Ethereum ICO. Grunfest himself, let me just get down to the spot, guys. I know this is long, but bear with me. Grunfest himself stated that if the SEC brought an enforcement action under these circumstances, it would raise serious concerns about the Commission's exercise of discretion. Grunfest questioned whether there was an improper motive behind this suit. On December 21st, 2020, Clayton met with Gary Gensler, suspected to be appointed by Biden to be the next SEC chair. The next day, on December 22nd, 2020, despite warnings and concerns of Grunfest via reporting by Charles Gasparino and Eleanor Tourette at Fox Business, Clayton voted against his fellow Republicans, Pierce and Roisman, and with Democrats, Heron Lee and Crenshaw, in a 3-2 vote to file the case. The next day, Clayton left the SEC forever. His firm, Sullivan and Cromwell, represented Consensus and Joe Lubin in its purchase of Quorum and the JP Morgan coin, a direct competitor of Ripple and XRP. Clayton also went to One River after its $1 billion bet on Bitcoin and Ethereum. After collecting $15 million in retirement benefits while at the SEC from Simpson and Thacher, a member of the Ethereum Alliance, Hinman unretired and went back to Simpson and Thacher. Hinman also brought with him the past enforcement director, Mark Berger, who also became a partner at Simpson and Thacher. Oh, and I almost forgot, Hinman also became a partner at Andreessen Horowitz with the same people that helped write the Ethereum free pass speech. But he must have forgot those Ethereum folks, because he met with them 6 to 8 times between December 2017 and June 2018, but stated repeatedly that when he looked at Ethereum, he doesn't see a third-party promoter pushing for the adoption of Ethereum. Yeah, he probably never heard of Web3. Now, read the fact timeline as well, and I challenge anyone to try to defend the SEC's conduct, because you can't. Some of you may still believe Ripple violated securities laws, but no rational person can argue XRP itself is a security per se, or the SEC has acted in good faith. So if you followed me on all that, it just shows you the timeline on, first Ripple takes all the right steps ahead of time to get legal advice to start their business, and even FinCEN comes after them, and they have a settlement with FinCEN, and even FinCEN in the government say that XRP is a virtual currency, right? And then, later down the line, all of a sudden, actually, no, forgot about this. The SEC did an investigation for 2.5 years and came to the conclusion that there wasn't a case, right? And then all of a sudden, what changed? 2020, Jay Clayton brings this lawsuit on the last day of his term. And, the 6 people that were involved in coming up with this case, they leave the SEC right after they file the case. You're telling me that that doesn't look terrible? There's nothing bad there? And Grunfest, this letter is I think, the most important part of this case. The past chair at the SEC is telling Jay Clayton, this is going to be a terrible thing to do. You can't come after XRP because there's no distinction between XRP and Ethereum, and this is going to look terrible for the SEC. And the fact, don't forget, you're going to hurt thousands and thousands of XRP holders all over the world. So he got all these this letter from Grunfest, and still Jay Clayton brought this lawsuit. It just makes no sense, right? Why would you, if you know you're going to hurt all these investors, like I keep saying, the SEC is supposed to protect investors. If you know you're going to hurt all these investors, why would you go about this in this way? And why would you state that XRP itself is a security? John Deaton always says he never would have brought this lawsuit if the SEC was only going after Ripple. But the fact they're stating that the coin itself, XRP itself, is a security, and even sales of XRP on the secondary markets are securities offerings or sales of securities, it made no sense to John Deaton, right? You're calling everybody that owns XRP right now a basic criminal because we didn't register our XRP as securities. This is why the SEC is dead wrong and all this. And, the big fact in all this is that if they actually thought that XRP was a security, they would have sought an injunction from day one and stopped the sale of XRP, but they did not. The fact that you have exchanges in the US that stop the sale of XRP, but you have Ripple and other, top executives and Jim McCaleb selling their XRP legally, I guess, that just shows you that this was never about XRP being a security. This was never about going after Ripple. This was all about a power grab by the SEC. There was that meeting between Jay Clayton and Gary Gensler right before Jay left, and it seemed to me that Gary Gensler wanted this case because he thought it was going to be a big case for him to start off in the SEC. if you think about it, the way I've been talking about Gary Gensler and the way we see Gary Gensler right now, he is this power-hungry politician that thought this case would be a big thing for his name. He would get a big settlement, and then continue on with this crusade against crypto, and it would be all about Gary Gensler, right? But the fact that Ripple's putting up this fight and they were ready for this fight is making Gary Gensler look terrible. And I said in my video a couple days ago, when the Democrats lose these midterms, Gary Gensler is going to be in the hot seat. So good luck, Gary Gensler. And you deserve all this. I hate to say it, but you deserve all this pain you're about to get. So moving on to the next thing I have here. So Dark Defender is a chart analyst that I follow. And I've been saying this regularly in the last couple of weeks, but let's just read his tweet and then we'll talk about it. But price action will happen before the settlement. It will be late for the most. To take their position. Most of us usually like to say, "Oh, I was going to get in, but I knew it, but I'm too late now." Action is virtue. Action with persistence is mastery. So I've been saying this for a while now. Don't think that this is gonna, all of a sudden they're gonna settle and then the price is gonna go up. Right? What's the saying? Buy the news, or buy the rumor, sell the news. Right? The price is gonna start going up before the settlement happens. Right? When there's talks about the settlement, that's when the price is going to skyrocket. So if you guys are sitting out there waiting, if you're sitting out there waiting for a settlement to get in, you're going to be late, guys. That's the bottom line. And even look at what Leb Crypto even says about this. And, this is kind of along the lines I'm thinking too. Leb Crypto is another chart analyst that I follow. Everyone is waiting on the settlement for XRP to pump. That's why it's definitely not going to happen as the majority think it will. XRP will either complete most of its bullish rally before any news on the settlement, or nothing will happen when the news comes, rather much later. So I think it's going to be a little bit of both. You're going to have a huge pump coming up to the settlement, and when the settlement comes in, like I said, buy the rumor, sell the news. Settlement comes in, price will dump, right? And then later on, obviously, XRP will be the only cryptocurrency with clarity. Then you'll see a massive pump after that. So all these people out there that just going to wait for a settlement or they're waiting to buy XRP. It's all about dollar cost averaging into these projects when they're consolidating, when they're at their lowest point, right? If you're just buying at when it's going up, that's how you get wrecked. That's how you miss gains, right? Like, it's all about, if I have any advice, and not legal advice, obviously, but if I have any advice about getting into projects, is obviously do a lot of research, do your TA, do everything you can possibly do, your due diligence to get into a project, but don't think you can just get into a project when it's already going up, right? That's how you buy the top. That's how most investors get wrecked. I'm going to wait for it to, be up 30% before I get into it. No, you want to try to anticipate these things happening, right? That's why they say dollar cost average. Slowly buy into positions, when it's consolidating or at its lowest point. So then when you get the rally after, you get those big gains, right? So like I said, not financial advice, but it's all about doing that due diligence, and it's all about TA, fundamentals, on-chain metrics. You do all this research, and then you get into coins that get into them before they pump, right? If you get into a coin halfway in its pump, then you're only getting half the gains. But the smart way is to dollar cost average into these coins as they're consolidating at the lowest points, and then when they actually make their move, then you get full gains, right? Then you get those huge gains, those life-changing gains that we talk about in this space. But like I said, not financial advice. But let's get into the next thing I want to talk about here. So guys, I saw Crypto Lifer post this too earlier today, but or someone in the Lifer crew posted this. 208 million XRP shoveled by Coinbase. Rumors possible XRP relisting sparkle. That's a weird way that news article said that. But anyway, we've been seeing a lot of movement of XRP in the last couple of weeks. Obviously, that basically 95% of exchanges in the U.S. have delisted XRP in the last year. So the fact that you're seeing all these exchanges moving around hundreds of millions of XRP, it just looks like there could be a relist of XRP on these exchanges. And it's obviously just a theory and people don't know for sure. But like I said, you got to look at these things, right? I've been, like I said in the beginning, I'm a nerd in all this. So I'm on Twitter, I'm in the news articles, I'm all over the charts. I am looking at any possible way to find out, when this settlement is coming or when the price is going to move. But, things like this will tell you that, obviously the exchanges are doing the same thing. They're keeping a close eye into this case. And as soon as they can relist, because think about it, exchanges make money on pumps and dumps, right? If you're buying, they make it off the fees. So if you're buying coins or whatever, selling coins on their exchange, they're making money. So do you think they want to miss out on XRP's huge pump they will have before or after this lawsuit is ending? Obviously not. So they want to list at the right time so they can make the most amount of money. So just get ready for this, because if there's all of a sudden a huge relisting on all these exchanges, that will cause a pump for sure too, right? So these are the things you have to look at in all this, right? So let's get into the last thing I want to talk about. So I saw this on Fox Business. I love Fox Business. They've been literally the only mainstream media outlet that's been covering this case, and they've been killing it, honestly. So they had so he was the head of the CFTC during the Trump administration. He's I believe it's Christopher Giancarlo. He's also called Crypto Dad. He wrote a book called Crypto Dad. Honestly, a great I believe him and who's the other guy that worked for the COO? Oh my God, what's his name? Brian Brooks. Him and Brian Brooks are the top two politician-esque people we need in Congress or in regulatory positions. Those two guys know their stuff, and they are such good proponents to this space. And I love hearing them talk, because they're obviously well educated and well versed in this technology and in this space. And so he was on Fox Business with Charles Gasparino, and it's a 6-minute long interview. I'm going to end the video on this, and then I'll end it. But just want to show you guys this, because he says that he came to the conclusion when he was at the CFTC that XRP was not a security, and he doesn't want to comment on it, because past CFTC chairs don't talk about ongoing investigations. They don't talk about the SEC's investigations and all that. But you can tell that he says basically Gary Gensler, what they're doing at the SEC is basically a power grab, right? It's all about Gary Gensler and the SEC. They want to make a name for themselves. They're trying to, most people say that the CFTC should be regulating this space, and the fact that the SEC is going after and calling everything securities just shows you this is a power grab, and that this needs to be stopped by the SEC. But let's just watch this interview, and then we'll end the video here.
SEC versus Ripple lawsuit raising questions as to how the case is going to end, not just for Ripple, but for the thousands of investors who own the XRP token. Joining us now is former chair of the Commodity Futures Trading Commission and author of Crypto Dad, Chris Giancarlo, along with, of course, our very own Charlie Gasparino. Chris, you've said publicly you don't think XRP should be regulated as security. So why is the SEC so adamant about this?
It's great to be with you, Cheryl. Thanks very much. Charlie, good to see you.
Good to see you, Chris.
You had Chairman Gensler on just, I think, a few days ago, and he made it very clear he wasn't going to comment on an ongoing enforcement matter. The same applies to former chairman as much as it does to current chairman. What I would say is, before the SEC launched its enforcement action against XRP and Ripple, I penned an op-ed along with my colleagues from Wilkie Farr and Gallagher in an international law review, applying the same approach we would have taken when I was at the CFTC to analyze XRP under that so-called Howey test. And we came to the conclusion in that 2020 article that it wasn't a security, and I stand behind that article today. But as for commenting on that specific action, once it's in front of the court, it's not for me as a former chair to handicap how the judge may rule in this case.
Well, Chris, this case, the ether is not before the court right now. At least it's before the court of public opinion and whether it is a security. But let's unpack this a little bit. Gary Gensler has consistently sidestepped the question if XRP is a security, because remember, they did some of the similar things they did on Ether, which is sell the token to help build out their platform, thus making it an investment in the SEC's view, obviously not your view. Then why isn't Ether a security? Because they did an ICO to help out help at some point build the Ethereum blockchain. So I guess my question to you, Chris, is if the SEC wins this case, does Gensler have to go back in time and basically consider Ether a security and ding the Ethereum people?
Well, it's the right question to ask, Charlie. And in my book, I talk about our analysis and our work with the SEC back in 2019 when I was chair of the CFTC and Jay Clayton was at the SEC, and our work looking at Ethereum. And it was the Ethereum precedent that we looked at in 2020 after I left the commission in coming to the conclusion that XRP is not a security. Right. So the analogy is certainly there, the precedent is there, and I think depending on how this case comes out, it could be very challenging for the way Ethereum is considered.
So you think Gensler could bring the case if he wins this one against Ethereum?
Again, I don't want to handicap what the SEC might do or not. I just, as a legal precedent, it would be challenging.
Yeah, interesting. Also, the fact that he doesn't comment on it sounds like he's at least thinking about it. The other thing I have to ask you is, I'm sorry, did I interrupt you?
No, I was going to say, look, in all fairness, there are good reasons why chairs and former chairs shouldn't comment on ongoing cases. It could do damage.
But Ethereum is not an ongoing case unless it is.
No. Look, my view is Ethereum falls on the CFTC side of the ledger as a commodity, and that's borne out by the work we did.
But Chris, he won't go there, which makes you think he is investigating. And I'd like to just turn this a little bit. Why is the SEC on your turf or your old turf? I mean, it sounds like, all we're talking about is the SEC going into these cryptocurrencies when you guys are at least legally, the main regulator. You're the ones that are supposed to figure out whether it's a commodity or security. You've obviously ruled that you thought XRP was a commodity, at least intellectually you believe that. What does the SEC do? Is this like a power grab by Gensler?
Well, Charlie, you've been around Washington long enough. You know that Washington is just a series of turfs and turf battles. That was one of the things that Jay Clayton and I really tried to put an end to when we were there. I don't think cooperation between the CFTC and the SEC has ever been as good as it was during our terms there. And I really recommend to my successors that they try to harmonize these things internally and not publicly.
Well, that is before I turn this over to Cheryl, because she has an answer, she wants to ask you a question, that's a really diplomatic way to say Gensler is making a power grab, but I won't, or a turf grab, but anyway, go for it, Cheryl.
I didn't interview on those last topics. I'm not even going to go there. Not my show. But I do want to ask you about just regulation in general. I mean, I think the biggest question for the novice crypto investor is what's the regulatory environment going to be for cryptocurrencies? I think there's still a lot of fear out there.
Absolutely, Cheryl. We have to start getting this right. This is not a novelty anymore. This is the future of finance. This is the future of money. This is going to affect the role of the dollar. It's going to affect the standing of American banks in the global financial markets. We have to start taking this seriously. And earlier this week,
Chris, I want to just ask you this. We do have to take it seriously, but is the current regulatory environment up for it, or do we have to find something else, like create something else?
Yeah. Well, Charlie, earlier this week I put out actually fundamental principles for what we need to do. And the first step is this needs to move to Congress. This is not for the Biden administration, Trump administration, some other administration to willy-nilly change it every 4 years or every 8 years. We need Congress to step in, and in a bipartisan, and it must be bipartisan so it stands the test of time, in a bipartisan manner, establish a regime to regulate this new development.
There's so much there.
Fundamental.
So much there. You have to come back and talk more about.
So exactly what he said there at the end. We need Congress to make real regulation so it's strong, so it can't be changed from administration to administration. Also, when they're talking about this power grab that the SEC and Gary Gensler are trying to make here, it's so amazing to see Gary Gensler and this regulation by enforcement strategy that they have here. It's totally stifling innovation in this country because they're putting fear in the market. These companies, there could be an American company out there that has this great technology and using cryptocurrency, and they're afraid to come up with it because of enforcement from the SEC. I mean, you look at that BlockFi settlement they just made for $100 million. $100 million is a huge amount of money. That would put most companies out of business, right? The fact that 100 million didn't put BlockFi out of business, I guess tells you that they're making some money. But what I'm saying is that fear of a settlement like that, or fear of an enforcement like that, and having to pay out that much money is going to stifle innovation in this country. Companies will go elsewhere. They'll go to the UK, the Euro countries, Japan, Singapore, anywhere but here if they think that they're going to get hit with an enforcement action along the lines of millions of dollars. So this is exactly what is wrong with the SEC and how Gary Gensler is going about this. It's terrible for this country. And like I said, we need Congress to come in and actually, get SEC and Gary Gensler out of there, because this is dangerous, right? Other countries are going to, like I say in this channel over and over again, other countries are taking charge in this technology. And the fact that the SEC and Gary Gensler are stifling innovation in this country, you should all be worried about that, right? So make sure you guys, like I keep saying in this video, write your senators, write your representatives, and vote for pro-crypto candidates in the midterms, guys. So I'll end the video there, guys. Just remember to like and subscribe, and definitely comment, hit the bell for notifications. And don't forget, I am not a financial advisor. Do not take anything I write or say as financial advice. This is for educational purposes only. And thanks, guys, and we'll see you on the next one.